Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Thank you, everyone. Please be seated. Welcome to an evening oral argument in Waverly, Iowa, with the Iowa Supreme Court, and we thank you for the invitation. And we are pleased to present to you a real case tonight. If it wasn't heard here tonight, it would be in Des Moines at our building. So it's nice for a change of scenery. Thank you for being here. And it looks to me like counsel are ready to proceed. Tonight we have the case, and it will be submitted upon the completion of oral argument. State versus Stephen Arrieta. And the parties are ready. Mr. Arrieta is a counsel. Is Colin Murphy. You may begin.
Good evening, Chief Justice Christensen. May it please the court. For nearly 40 years now, canine teams, the handler and the dog, when they're looking to deploy the dog onto a vehicle, have some very simple rules to follow. The handler will walk the dog around the car. That dog will sniff the airspace around the car. And if the dog alerts to the presence of narcotics, that gives law enforcement probable cause to search the vehicle. Those are very simple rules. It's nearly a bright line. Walk the dog around the car, sniff the perimeter. Handlers and dogs have strayed from that principle. Tonight before you is one of those situations where the handler directs the dog to sniff certain parts of a motor vehicle. Although the fact of whether or not the handler actually made physical contact with the vehicle may be in dispute, there is no dispute, and I think the state concedes that the handler did direct the dog to sniff certain parts of this vehicle. The sniff in the areas where the handler directed the dog to address was immediately followed by an alert. And the alert's important in this case. It's the final response by the dog when the dog sits, which it's trained to do in the presence of narcotics. That's the final response. It's an objective visual that anyone watching would understand that the dog is in the presence of narcotics that is trained to detect. So this framework that's been established now for the last 40 years, that's based on an expectation of privacy. Because the dog is not revealing anything that is illegal to possess. So it's illegal to possess controlled substances. The odor of those controlled substances is what the dog is alerted to. And so it's clear that drivers, occupants do not have an expectation of privacy in controlled substances. But this situation presents a different set of facts. We have a trespass onto this vehicle.
Let me ask you about that issue. It's two parts. One, what is the additional unconstitutional intrusion that's affected by the dog touching the vehicle as opposed to the dog just walking around the vehicle? And then two, what is your best authority for the proposition that mere touch of a chattel is a trespass?
Well, a few years ago, I appeared before this court and argued State versus Wright. And as the court's well aware, the Wright decision establishes a two-part test in determining whether or not a constitutional search has occurred when trespass is involved. So that test takes two parts. Was there deliberate physical contact with an effect, a constitutionally protected area? In this case, it's not really disputed that a motor vehicle is an effect. So is there deliberate physical contact with an effect? And is that coupled with an intention to discover information, something for use in a criminal case? Now, the dog is an extension of the handler. It's leashed by the handler. The handler controls the dog. In this situation, the dog putting its paws on the vehicle in order to sniff areas that it could not do with all four paws on the ground, that is the search that we're alleging.
So is it your contention then that the search occurs when there's a physical touch combined with the search for information, even if it doesn't amount to a trespass at law? Or does there have to be a trespass as a threshold determination under the right test?
Under the right test, if there's contact with an effect coupled with the attempt to discover information, that is the trespass. And so here where the dog is touching the car in order to sniff areas, I think that trespass is satisfied. Whether it's momentary or multiple times, I don't think that matters. The right opinion address.
Well, in Wright we said that the trespass has to be an unlawful invasion of the right. So the unlawful act in Wright was the police officer's violation of the ordinance as they were taking possession of the trash. Here you just have a de minimis touch, and I guess, are you saying that the touch itself is enough regardless of whether it's actually tortious or unlawful? Or do we have to find first that there is a trespass to chattel before that right analysis is implicated?
I think the minimum touch by the dog, because Wright uses de minimis, I think the dog merely putting its paws, it's self-evident what the dog is doing. The handler has directed him to sniff certain areas of the vehicle. So I think it's self-evident that what's going on is an attempt to discover information about what is potentially inside the vehicle. But if you're talking about, do we need some type of tortious trespass in order to make the constitutional trespass announced in Wright applicable, I think that we could look at Chapter 716.7. So if you look at Section 1A of that, property as is defined in the trespass statute includes a vehicle. So we have a vehicle in this case. It satisfies the definition for property under 1A. If we go further and look at what constitutes trespass, so I'm looking now at subsection 2A4, that sets out being upon or in property, placing something animate or inanimate on there without the express or implied permission of the owner, the lessee, or the person in possession. So if we take that definition and apply what happened here, we have the exterior of the vehicle, which is being upon property. The handler placed an animate object, the paws of the dog, clearly done without Mr. Arrieta's permission, who was not only the lessee, but also the person.
So let's assume it wasn't a dog. Let's assume that the officer decided that they were going to look underneath the truck. And during the course of that investigation, the officer's hand touched the side of the truck to brace himself to peek under. Is that an unlawful trespass and an unconstitutional search?
I think there is a difference between commercial motor vehicles and regular private vehicles in the scenario that you've described, because there is some authority, inspection authority, that would enable a DOT officer to get underneath a vehicle to look for something. I don't think merely putting his hand on the vehicle to get underneath it is necessarily the trespass that we're talking about. If bracing enables them to see something that they couldn't otherwise see, perhaps that is a trespass, but under these circumstances, they do have some authority to get under a truck. But I think it's important to keep in mind that's not what the officers did here. They used the alert by the dog to go into the passenger compartment, the sleeper compartment of the vehicle.
I want to back up a little bit. You were talking about the officer pointed or did something. Obviously, dogs are kind of short. Their noses are not going to get up there, so they either put their paws on. What if the officer picked up the dog and stuck his nose up there, real close to there?
I think that there would be nothing preventing the handler from picking up the dog and placing it near the vent.
How is that different than him going right there?
Well, he's definitely directing the dog, but the dog is making physical contact.
Right, but I'm stopping short of the physical contact. I'm just saying pointing or just lifting a dog to make him taller. Might have been a short dog.
None of those situations involve physical contact with the vehicle.
No, but I'm asking, you're thinking there's even a problem with directing the dog where to go. Isn't that part of your argument as well?
It is part of the argument to the extent that I believe the officer touched the car because in the video you can hear him describe to another officer what he did, and that he says hit the seams, touch the seams. He's talking about doing that. He knows where I'm going when I'm asking him that question at the suppression hearing. And so he's going to back off that. Well, I don't always touch it normally, but the dog touches it. And so if he's pointing out areas to sniff and the dog simply sniffs that area without making physical contact with the car, we don't have this issue. As soon as the dog's an extension of the handler. And we see law enforcement from time to time during traffic stops, they will come up to a car, they will place their hands on the car, and they will lean in, breaking the threshold window, the plane of the window, to sniff the interior of the car. We see that in traffic stops. And so I think the same argument would apply. They cannot make physical contact with the vehicle. If they want to stand outside, it's a free air sniff. As soon as they're sniffing something other than free air, then we have a problem. And so the way that you describe it, lifting the dog up, I don't see a problem with that. As soon as the dog makes...
How is this not free air, though? Even if the dog's paws are on the exterior of the vehicle, the dog's sniffing air that's outside of the vehicle, right?
Well, let's remember what happened in this case. The handler walks the dog around the truck, and the dog makes no alert. So they do a complete lap around the truck, no alert. They do a second lap around the truck, and that's where the handler goes through this detailing process where he's going to have the dog focus its attention on certain areas. It had already gone by this area 2 or 3 times.
That's what I was just getting at with you. What's wrong with that detailed focus? I mean, what's the difference between that and lifting up the dog? And I'm stopping short of the dog touching the car or the vehicle. Or do you have an argument against even that detailed, focused attempt?
I think directing the dog's attention to sniff certain areas of the car. I do have a problem with more than one pass, because I think that goes to the reliability and whether the dog's well trained. If I walk the dog around the car and the dog never alerts, how many passes are we going to allow the handler to do? If we allow one and then we allow this detailing pass and nothing happens on the detailing pass, we allow a 3rd pass, 4th pass, 10th pass.
Well, that's not this case. This was second. Wouldn't that be reasonable?
You're right, but the point I'm trying to make is that when he has the dog sniff an area that the dog's already been passed 2 or 3 times and the dog does not alert, but the only reason he alerts is because the scent is now up here, above the ground where the dog cannot access it. The only way that he can access it is to trespass on the vehicle.
Can I bring you back to Justice McDonald's discussion about right? Are you bringing this under the 4th Amendment, under the Iowa Constitution?
Under both.
With respect to the 4th Amendment, do we look to local Iowa law to determine if there's a trespass? I know the Dorff case from Idaho. We spent a lot of time, talking about historical Idaho law. Are we looking at Iowa law, or are we looking at trespass generally?
Well, when Jones first looks at trespass under the 4th Amendment, it's looking at whether or not there were historical precedents that were in effect at the time of the founding, so 1791. And I think in the footnotes in there, and that has been an issue where courts are talking about whether or not we need damage to occur in order for a trespass to take place. When Jones is decided, we don't need damage for one. And that's consistent with Iowa law. If you look at 716.7, there's no mention of any damage. And so whether we look at the historical precedent at the time of the founding or contemporary law in Iowa today, there is...
Isn't that contemporary law having to do with trespass to real property? Has it ever been applied to trespass to chattel?
Well, I think that there's discussions in Dorff, there's discussions in Jones about trespass to chattel, because ultimately where that argument goes is whether or not there's...
But referencing our Iowa law, we don't have a criminal statute on trespass to chattel, do we?
To the extent that vehicle is defined in trespass, 716.7, vehicle is among the definition of property as it applies here. I think that would be the trespass and chalice that would be most relevant.
But Counsel, in the trespass statute, though, isn't the law talking about leaving an inanimate object on the property at issue, which didn't occur in this case? It's not a trespass under the statute you're referencing. Isn't that right?
I don't think it's really discussing the degree. It says placing thereon. It doesn't, there's no temporal requirement.
It says an inanimate object, right?
I think it says
Animate or
and
inanimate?
inanimate. And I would consider the dog to satisfy that as an animate object.
What about a hand?
I think the hand, I mean, it's an extension of the officer.
So are you saying that under your interpretation of the statute, if somebody walks onto somebody's property, a sidewalk, and they knock on the door, and they touch it 4 times, that's a criminal trespass?
I don't think that qualifies as criminal trespass, but we have to think about
Then what's the difference between that and the dog?
the dog is an extension of the officer who, under trespass, if they're looking for information to use in a criminal
But if the
case.
officer can't trespass, how can the dog, as an extension of the officer, commit a trespass that the officer can't commit?
Well, I don't think the officer's necessarily trespassing by simply knocking on the door. They might be in the curtilage of the property when they're doing that. And we haven't really added whether or not they're looking for anything at the time. There is, and I know I've got about 30 some seconds, there is a question about the unreasonable delay.
No, I think it's growing. Look at the number.
I've got 45.
It's getting bigger. You're past that much. It's over. Your red light's on.
Thank you.
You bet. You get to come back. Otherwise, I'd probably be a little bit more generous. It's kind of confusing. And by the way, for you watching, there's a light up here that the attorneys watch. Green light, yellow light, red light. You probably have a pretty good idea what they mean. Mr. Duden.
Madam Chief Justice, and may it please the Court. Good evening. Mr. Arrieta's argument fails for a number of reasons, but predominantly because a trespass did not occur here within the constitutional sense. There was no unlawful intrusion combined with the touch. The touch did not exist to actually inform the officers or the dog of anything specifically. And under its plain terms, as we understand it from State v. Wright, as we glean from other cases from the United States Supreme Court and even the federal circuits as well.
Counsel, does it have to be a trespass? I read the Jardines case as talking about an intrusion upon, but the majority opinion in that case doesn't actually use the word trespass.
Certainly. Jardines does not use the word trespass, that's correct. What it does use is it's understood from a trespassory sense, though, based upon the curtilage of the home, when the license would expire from being able to be present any longer. The bringing of the drug-sniffing dog onto another person's property for the purpose of sniffing around at one's curtilage is protected under Jardines. So the question then becomes whether or not the officer and the dog are somewhere where they have the legal right to be. And here there's no question that the officer and the dog were present in a place where they had the legal right to be. So Jardines actually supports the state's contention here that it doesn't change or undermine the ability for a drug dog sniff, or a canine sniff in this instance by Titan, to constitute a trespass or be unlawful.
What about the Hicks decision? It seems like to me that's the one that seems most on point for this case. So if you recall, Hicks is the officer in a lawful position, I believe, and then lifts up a turntable or a stereo to look at a serial number, I think, on the bottom of it. And the court says that that slight touch, combined with the search for information, constitutes a search.
If I remember correctly, that would constitute a search because it occurred within a person's home and it extended beyond the right or license, I believe, of a search warrant in that case, or at least beyond the exigency here. Because cars are different than homes within this context, they are historically and in fact entitled to fewer protections because they're thrust into the public space.
So is it your position then that that officer wasn't in a lawful position when the officer lifted the turntable? Because I thought he was in that case.
I believe he was in a lawful position, but that his search extended beyond what was lawfully permitted. And here, that would be the distinction. Because we are looking at the exterior of a car versus the interior, this case is very limited in how it's addressed.
Could a police officer use his hands to prop himself on the top of a car and look in the sunroof?
Certainly, the touch that would be aided there could be something a little bit different because it's at the top of the car necessarily, but the touch itself wouldn't actually inform you of anything else. And it's again to the exterior of a vehicle. So I don't believe that it would be essentially problematic under the existing jurisprudence.
So your distinction is that whether or not the touch itself is providing the information? Is that your...
In part, yes.
Okay, so if the window is open and the officer leans just barely across the plane of the window, now are they inside? What's the difference there?
If I understand your question correctly, with regard to the smell, for instance,
Right.
the smell would again be thrust into the public space, so it wouldn't be problematic for breaking the threshold in that instance.
So it's not a problem for a dog or officer to lean inside of a car, just for the purposes of smelling.
While it may not be the facts that we have here, certainly in State v. Stevens, the dog put their nose within the realm of the window where it was cracked.
Let me give you another hypothetical. A police officer sees a car that's stopped with the engine not running. He suspects that this driver has been driving intoxicated, but has no probable cause. So to determine if the car has been driven recently, the cop puts his hand on the top of on the hood to see if the motor's warm or not. Is that unconstitutional?
Certainly other courts have said that it is not unconstitutional because it's a de minimis impact on a person's reasonable expectation of privacy. That would go to Wright's second contention, that is what positive law or what we would understand as being reasonable in a common sense understanding. Courts did not necessarily, the other court, if I remember the decision correctly, did not have an issue with the touching of the top of the car.
Have any court since Jones, applying the Jones standard, found that way?
Not that I know off the top of my head, but quite possibly other courts have found the contact with a car for the purposes, the exterior of a car, being done for purposes of discovering something. For instance, United States v. Richardson out of the Fifth Circuit spoke to whether or not an officer's tapping on a tire, which was wobbly, to see if the tire was hollow, for instance, was in fact a trespass underneath the Jones standard, but was not an unreasonable one because the proffered reasoning was for a safety concern there as well. So
how does that apply in this case then, if we're going to follow that reasoning?
So in United States v. Richardson, if we applied the same kind of context here, even if the court were to find that exterior motor vehicle contact by either Titan or Chief Deputy Luther in this case qualified as a trespass, it certainly wasn't an unreasonable trespass. Again, Jones stated that they were just adding to, Katz was an addition to the property baseline.
So that's the question that I had. So Jones and Katz, are they different standards, or did they go? Is there a way that they work together?
Jones' position would say that there's a way that they work together. In this instance, I believe that could be seen potentially under the second facet, where they're drawing the reasonable expectation of privacy analysis from, where the source of some property right stems from state law specifically oftentimes. And in this case, the state law specific, or the positive law is addressed specifically in Wright, for instance, the source of the ordinance in that case. Here, we don't have anything that would say that a person touching the exterior of a vehicle necessarily, without causing any damage, does not necessarily qualify as an unreasonable intrusion.
Counsel, I was looking for the 716.7 discussion in the briefs. I didn't find it immediately. I apologize for knocking over my thing earlier. Could you address that argument, though, about 716?
Certainly. As I believe Chief Justice Christensen noted within her dissent in State v. Wright, for instance, it notes that a trespass to chattels, while may not be separate and distinct under 716, would still require some damage to be actionable. And indeed, Justice Alito in Florida v. Jardines also noted in his special concurrence that under existing modern law standards for trespass, some damage is necessary in order for it to be an actionable standard.
Well, but counsel, I think that was a dissent in that case. There was no damage caused in Jardines, and I don't think there was any damage caused in Jones either, was there?
There was no damage, I believe, in either of those instances specifically, but they're distinguishable in some respects.
Well, but so damage isn't the thing that we're looking for, are we?
So some more substantial intrusion would be what we're looking for here. For instance, in Jones, the intrusion that would have occurred in that case would be the 28-day extension of affixing a GPS tracking device onto a person's car. Here we
That'd be the inanimate object being left under Iowa trespass law. And we have no such inanimate object in this case, do we?
We do not, Your Honor.
Yeah, I mean, looking at the trespass statute, the definition that probably is a high watermark for the defendant in this case is being upon or in property and wrongfully using, removing therefrom, altering, damaging, harassing, or placing thereon or therein anything animate or inanimate without the implied or actual permission of the owner. The dog didn't do that, did it?
No. The dog left nothing behind after touching it. The record's absent and devoid of any information regarding damage. Potentially where Jardines, for instance, is distinguishable is that it was again to the curtilage of a home. And so they extended the lawful license for where they were allowed to be. Here, there's no question that the actual inspection that was occurring at the wait station was proper. And
let's turn to that for a second. The inspection may have been proper to begin with, but it sure seems like it took a long time. Now, as I understand the timing, the defendant arrives at the weigh station around 12:30 in the afternoon. Is that correct?
At about 12:35 is when he was pulling into the station.
And then by 1:30 or so, they've cleared up. They know it's not a stolen vehicle. Is that correct?
1:34 is when dispatch gave that call saying that Colin.
And then that's around the time, it's after that they call in the canine. Is that right?
The state would disagree with that, specifically by working backwards. While the Court of Appeals and the District Court specifically focused on this 1:45 timeline, the testimony by Chief Deputy Luther actually says that he arrived at the weigh station at around 1:45, not that he was called to it.
Okay, so the version of the Court of Appeals that he arrived around 2 p.m. the state disagrees with that?
Yes, based upon the analysis of when he would have to be called. So by working backwards, he would have to be called before 1:45 in order to be there in time for his dash camera, for instance, to begin running around 1:53 p.m.
And then the testimony, as I recall, of the officer Walkins, is that his name, who called in the Deputy Luther with the canine. Officer Lukens said that when he called in Deputy Luther, everything was done except going over the paperwork with the driver. Isn't that right?
And no citations at that point in time had been written.
But that doesn't sound like something that would take all that long, does it?
It took a significant amount of time because of how the traffic stop unfolded. For instance, according to the motor vehicle guidelines for level 3 inspections, if everything went smoothly and checked out fine, it would take at a minimum 45 minutes, according to the Department of Public Safety's outlined standard for a level 3 inspection. That would be because of the bulk of the volume of the documents to go through. So here, this was not a perfect traffic stop. Mr. Arrieta had significant discrepancies and issues with his logbooks that required a lot of time to go through. And in that span of time, the citations had not yet been written. This is all expanded and compounded by the fact that his VIN number had been reported as stolen. So that was an overlay, that was a consideration for both Officer Watkins and Chief Deputy Luther. So what we have here is at 12:39, the inspection would have been opened. In a COVID time frame, Mr. Arrieta remained in his vehicle because of this. He had a highly editable logbook, and he emailed his logbook records and information to Officer Watkins. When he began working through all of the documentation, he received notice that the vehicle's VIN was reported as stolen. And so over the course of the approximate hour that followed this, he was looking into a number of things, from commercial reasonability of transporting one installation staff on a highly known to be a high drug trafficking corridor between Texas and Minnesota, that he knew Mr. Arrieta was traveling from Minnesota back to Texas after just one night, that he was noted to have jumped hundreds of miles on occasion, according to his logbook, which violated the regulations of for commercial trucking, and he did so and traveled at a high rate of speed without seemingly taking any breaks over time. All of this was compounded by Mr. Arrieta's statement also that he was usually an intrastate driver, but was traveling out of state, maybe from Texas to Oklahoma and Oklahoma to Minnesota here. And it wouldn't have been a profitable way of evaluating things.
I want to ask you a question. Did the defendant, in your opinion, preserve that argument regarding the trooper lacking authority to search the passenger seats, the passenger area during that level 3 inspection?
No, Your Honor. Specifically, Chief Justice Christensen, it wasn't preserved because there was no real challenge to what would be incorporated within the scope of a level 3 inspection until the reply brief was filed. So it wouldn't have been a preserved argument that the state would have had the opportunity in the spirit of fairness to respond to. However, even outside the record, there's no basis for believing a traffic stop in this context, in a level 3 inspection, would occur within the span of about 10 to 15 minutes. And certainly that's not what we have here under the regulations minimum guidelines of that 45-minute window. There's also nothing to say that a level 3 inspection couldn't become a level 2 inspection, for instance, and now the minimum is 1 hour. In fact, if you Google it, like I had to in this instance to be able to find out, it's not uncommon for inspections to be increased if certain deficiencies are noted during the course of the inspection.
I want to make sure, am I correct that there was no dispute as the probable cause? I mean, getting to the level 3 inspection doesn't seem to be challenged. So then I think the biggest red flag had to be, this rig might be stolen. I'm sure red alarms went off. Okay. So then he started doing some other things and called the K9. Am I correct that after the K9 guy was called, but before he arrived, that's when they learned, okay, maybe it's not stolen?
That's correct.
The K9 was either already on their way or maybe there but hadn't quite started the walk. Is that right?
Yes, Chief Justice Christensen.
Okay.
In this instance, it would be that 1:45 p.m. if he showed up at that point in time, which was what Chief Deputy Luther's testimony was, that he arrived around 1:45 p.m. Again, it's all approximations because it wasn't necessarily reported by Officer Watkins, for instance. What we do know is that the police station for which he was traveling from the sheriff's office was about 20 minutes away, or 16.1 to 17 miles away, and according to Google Maps, that would take between 18 and 21 minutes, depending on traffic patterns. And so if he arrived at 1:45, he would have had to be en route already at its fastest point. That is, Titan already being ready and in a car, his patrol vehicle being gassed up, on, and ready to go, and him out of his meeting with the approval of the sheriff and being dispatched accordingly before 1:25 approximately, I'd say, given that his testimony was about plural minutes.
Can we talk for 1 second about the Dorff decision? And I assume that you believe it was incorrectly decided. Why don't you give me your best argument on where the analysis was incorrect in Dorff in the state's view?
Dorff's analysis departs primarily on 2 points. One, without an uncited, it's not cited anywhere as to an authority position that there is no difference between the interior and exterior of a vehicle. And 2, it broadly defines trespass well beyond what we should be able to define it as here. For instance, they trace it back to Blackstone's definition in the commentaries of law, but take no account into a modern analysis of what it is able to be considered today. Here in Iowa, we don't have similar laws like they do in Idaho, where the English common law remains on the books unless it's unsettled or set aside by an Idaho statute, the Idaho Constitution, or the United States Constitution in that case. It gives Iowa greater context for modern-day trespass analysis, but it overlooked the evaluation of what damage might occur or how things would proceed. As the first dissent mentioned in that case, in a 3-2 decision, it thrusts them back into the murky waters and reduces the clarity of the Fourth Amendment's decision, because we don't know what trespass would go so far. For instance, the hypotheticals presented by the majority simply speak to whether or not an officer touches their hand, as you mentioned earlier, braces it on top of the car and looks through a window where they can see through plain view, drugs being present. It says that that could be potentially a trespass, but they'll leave it for another day. Certainly, under our existing analysis, and even under Wright, it wouldn't qualify as a trespass because that de minimis contact wasn't matched with anything of a positive law source to make it unlawful, for instance, or tortious or otherwise prohibited. As the analysis went through in Wright, it traced its roots to the clear common understanding of common law trespass within the context of a home and its curtilage, albeit the dissents would point out that it still required in a trespass to chattel context some damage, which the state would assert is still being required here today in this instance. And there's no similar companion to the ordinance as it was in Wright. So dwarf stretches too broadly, sweeps too quickly, but its reliance is also built upon an Idaho interpretation and a series of cases that Iowa does not utilize or incorporate under its existing jurisprudence. So it's not only distinguishable, it's not only wrongly decided in the state's opinion, but it would be distinguishable under our existing law today.
Anyone else? Okay. Thank you. Mr. Murphy.
Thank you. I'd like to return to that discussion about the unreasonable delay because I think that the record shows a timeline that looks like this. Mr. Arrieta is stopped at the weigh station at 12:39. And even if we credit Officer Watkins' time that he took to do everything that would need to be done in a level 3 inspection, he would be done with that inspection by 1:25. So bills of lading, certificates of registration, the logbook, all of those things, 43 minutes. If we credit him 12:39 to 1:25, he's done with the level 3 inspection. When he receives word from state radio that the trailer is no longer reported stolen and they cannot hold Arrieta on that any longer, he doesn't make the call to Chief Deputy Luther for another 10 minutes, 1:45, and Chief Deputy Luther arrives, I believe, at 2 o'clock.
Is she making it seem like that's all that mattered was the stolen trailer? I mean, there are other issues that the officer's still looking at. And anybody who's been pulled over, it never goes as quick as you'd like.
Chief Justice Christensen, you are correct that there are 2 other issues on which Officer Watkins relied, in addition to the stolen trailer that is no longer at issue. He continued to detain Mr. Arrieta because of discrepancies in the log and this belief that because he was traveling from Texas, which he referred to as a source state, to Minnesota, a target state, that he must have been trafficking in narcotics. And so...
Well, there's a difference between, you wrapped up 2 in 1. You're trying to make it less than I think the evidence shows. He wasn't hooked up, whatever machine it is that I understand for truckers.
The ELD.
The E what?
ELD.
ELD, there you go. I Googled it too. The ELD wasn't hooked up, so right away you don't have the data being downloaded to keep track, so then apparently he's manually overwriting it. So that's one thing all by itself. Then another one is the multiple inconsistencies where he would change locations. Those are 2 different things, in my opinion, in addition to the concern about the traffic area being a corridor for drug delivery or drug transmissions, and also that concern about you're hauling insulation from Minnesota to Texas. That apparently just seemed weird. So and to top it off, he failed the pre-pass for vehicle registration to begin with. So there's more than just the stolen vehicle.
But we know as far as the timeline is concerned, by the time he had not called the dog yet. And so it's only when they are told that they can no longer hold him for the stolen trailer that he then calls for the dog. And here's what's interesting. He really hasn't finished the level 3 inspection. This thing is continuing. He knows, and this court knows from Salcedo, that officers are involved in a competitive enterprise to ferret out crime. He is going to drag this out as long as he can. And so when Chief Deputy Luther gets there with the dog, he's still not done reading the log entries. And so now we're talking about 12:39. Remember, this started, the whole reason the truck was reported stolen is because he had already started the level 3 inspection, saw the registration, called that information in. So we know that the inspection started very early in the process. 12:39 now to 2 o'clock by the time the deputy arrived.
Here's what bothers me a little bit, and tell me if I'm reading the record correctly from the suppression hearing. He calls, Watkins calls for the canine after having resolved the stolen vehicle issue. Then at that point he says the only thing he still has to do is go over the paperwork with the driver. Then Luther testifies, I show up whenever it is, around 2 o'clock or whenever, and then Luther says that Watkins told him at that point he's going to call the driver in to do the paperwork. Well, why wasn't he calling the driver in to do the paperwork before? Well, it sounds like maybe he wasn't because he was waiting for Luther to show him.
Correct.
Am I reading that correctly?
You are reading that. That's exactly what happened. If he calls Mr. Arrieta in and deals with the paperwork issue, he issues him a citation. Mr. Arrieta is free to go at that point. But by not issuing him the citation or resolving that paperwork, it's no coincidence that the record shows that as soon as the handler comes in to say the dog alerted, that's when he's coincidentally wrapping up with the paperwork. I don't think that that's any coincidence. And Salcedo, this is practiced by law enforcement in certain situations where he knows he can't let him go. He still wants the dog to sniff the vehicle, and so by delaying it, he allows the handler to then walk the dog around the car. So I think you're reading that correctly.
Chief, can I ask one more question? Can you respond to the state's position on Dorf?
There is a slight difference, but I don't think that there's a distinction between Dorf and Arrieta that I don't think makes a difference here. I think the case in Arrieta is actually stronger than Dorf because if you recall from that opinion, the justices in Idaho are talking about that this dog was acting instinctually. So we still have, in the Court of Appeals, and they didn't raise this in the Arrieta opinion, they have a case, State versus George, that talks about if a dog's just being a dog, or if the handler is facilitating or instructing or doing things with the dog. That's the situation in Dorf. You have a dog just doing dog things, happens to be trespassing on the vehicle. Arrieta is different because the handler is directing the dog to do something.
What about with respect to the trespass itself?
I don't think that there's any difference between the trespass in Dorf and the trespass.
So does the difference between Idaho law and Iowa law make a difference?
I think from the Fourth Amendment perspective, no. I think that with right in Article 1, Section 8, there might be a difference because of how we've developed that trespass body under right.
Are cars different than other effects?
I think the car is going to probably be the most popular effect that can be trespassed upon by law enforcement or a canine.
Well, if we were to go with your proposed argument here, it, I think, would apply to effects of all sorts. So, luggage, an officer wouldn't be able to investigate who owns a piece of luggage by lifting up a card on it to see who the owner is. It wouldn't be able to touch it, lift it to see if it's heavy. I'm just trying to think of how far this argument goes.
Well, we can go back and look at like the place doctrine. So we're talking 1983, search of luggage. That was a free air sniff of the luggage. And so the dog was not trespassing at all on the luggage. Maybe we can equate it to a situation in a post office where there's a suspicious package and postal inspectors will pull those packages off, set them aside for purposes of having the dog walk around them. I don't think the postal carrier moving the package is necessarily a trespass.
But if the dog then brushes its nose against that package, it's a violation?
I think that there's a question about whether or not that constitutes a trespass. Yes, because there is physical contact made. We can't ignore that. And it's clearly done with an intention of locating something. And it would be interesting if the dog is not alerting as it goes around the package, but then presses its nose into the package and then alerts. I think that you'd have a trespass question. I mean, it'd be fact-based that would have to be developed, but I don't think that we should be in the business of separating one effect from another. The effect is the effect, it's personal property. And so if there's physical contact with that for purposes of discovering information, I think that that's a trespass.
Chief. Just to be clear, I asked the state, I didn't see 716.7 discussed in the briefs. Am I correct? It's not discussed in the briefs?
You are correct.
Thank you.
That was not raised in the brief. I raise it only because to the extent that there's some contemporary discussion about what Iowa considers to be trespass, I don't think that we can ignore what the legislature said constitutes trespass. You've already decided what a trespass is from a constitutional standpoint, but if we're going to look at it from a statutory standpoint, I think that 716.7 would be viable.
Was there any reason it couldn't have been in the briefs?
There's no reason it couldn't have been raised except for I'm looking at it as an extension of right. And it's only come up through preparation for this argument that I see that there's a statutory definition of trespass.
Thank you.
Looks like you're done.
Thank you.
Thank you.